But first, let's take a look at each of these three states. So California, the law of avoidance in California. Here's a California Supreme Court decision from 1897, folks. 1897, still valid law in California. But I wanted to give you the origin of this in California law. It reads, People v. Lewis, California Supreme Court, 1897, quote, California law nowhere imposes the duty of retreat upon one who without fault himself is exposed to a sudden felonious attack. This state has upheld a defendant's right to stand his ground and meet by force a sudden and violent attack. And if you're thinking, well, Andrew, this is a California Supreme Court decision from 1897. How do we know it's still good law? Well, here is the current California criminal jury instruction on self-defense, CalCrim 505. It reads, a defendant is not required to retreat. This is what a jury is instructed today in self-defense in California. A defendant is not required to retreat. He or she is entitled to stand his or her ground and defend himself or herself, and if reasonably necessary, to pursue an assailant until the danger of death or great bodily harm has passed. This is so even if safety could have been achieved by retreating. So California is a stand your ground state. It does not require the element of avoidance. In California, an act, a threat, or use of force is lawful if it meets only 4 elements of self-defense, not 5, 4. Innocence, imminence, proportionality, and reasonableness. Avoidance is not required. If a defender is missing avoidance, if they fail to take advantage of a safe avenue of retreat in California, that does not matter. It does not invalidate their threat of force, their defensive display as unlawful. That's California, one of the jurisdictions from which these judges were drawn. The second jurisdiction was Massachusetts. Well, Massachusetts takes a rather different approach. In Massachusetts, there is a generalized legal duty to retreat, and they enforce it very vigorously. In fact, Massachusetts is one of the most extreme duty to retreat states. In most duty to retreat states, they do not impose that duty, and there's only 11 of them anyway, folks. But in most of those 11 duty to retreat states, the small minority of U.S. states that are duty to retreat states, in most of them, they only impose that duty before you can use deadly force in self-defense. If you're only using non-deadly force in self-defense, you don't have a duty to retreat, even in the majority of duty to retreat states. In Massachusetts, they take a more aggressive approach on the duty to retreat. In Massachusetts, you have a legal duty to retreat, if safely possible, before you can use any degree of force in self-defense, deadly or non-deadly. So we just saw California, no duty to retreat, even if safe retreat were possible. In fact, you can pursue your assailant until the danger has passed. Massachusetts, absolute duty to retreat before you can use either deadly or non-deadly force in self-defense. So in California, where you only need 4 of the 5 elements to be lawful self-defense, innocence, imminence, proportionality, and reasonableness, in Massachusetts, you need all 5. Innocence, imminence, proportionality, avoidance, and reasonableness. So this is the Massachusetts, the relevant jury instruction. Now, Massachusetts doesn't really have any self-defense statutes. It's a weird state that way. All of its self-defense law is really found in case law, in appellate court decisions, but the jury instructions reflect the case law. So this is the criminal Massachusetts jury instructions 9.260, self-defense, duty to retreat. A person may use physical force in self-defense only if he could not get out of the situation in some other way that was available and reasonable at the time. Note that it doesn't say this is not a condition of deadly physical force. It's a condition of any physical force. It continues. The Commonwealth, the prosecution, may prove the defendant did not act in self-defense by proving beyond a reasonable doubt that the defendant resorted to force, any force, without using avenues of escape that were reasonably available and which would not have exposed the defendant to further danger. That's an absolute legal duty to retreat if safely possible, folks. Massachusetts Supreme Court decision, Commonwealth v. Santos, quote, the proper exercise of self-defense means that a person in the defendant's circumstances would reasonably believe he was about to be attacked, that he was in immediate danger of being killed or seriously injured, and that there was no other way to avoid the attack, close quote. So that, here's another decision, same thing. Massachusetts Supreme Court, 1963, Commonwealth v. Hartford, quote, the defendant was not entitled to a self-defense instruction because he began to shoot his gun rather than easily place himself out of danger by driving away. So that's Massachusetts. California, stand your ground. No duty to retreat, even if safely possible. Massachusetts, absolute legal duty to retreat before using even non-deadly force in self-defense. What about the third jurisdiction that this court looks at? That was Pennsylvania, right? Pennsylvania is kind of a hybrid because Pennsylvania has a very unusual stand your ground law. Pennsylvania essentially says that you do have a legal duty to retreat before you can use deadly force in self-defense, unless you meet an unusual condition, unless the person threatening you displays a deadly weapon. What if they're just threatening you with their bare hands? Then you do have a duty to retreat. What if they display a knife or a gun? Then you don't have a legal duty to retreat under Pennsylvania law. Do you think the survey was careful to collect that critical fact from the respondents in the survey? You think the survey authors, the authors of this study, were aware of this unusual wrinkle in Pennsylvania law, the only state that does this, that would make the difference between whether or not the threat of force, the defensive display was lawful or not? I bet they didn't. So here's the relevant Pennsylvania stand your ground law, statute 505, use of force and self-protection. An actor who's not engaged in a criminal activity, who is not in illegal possession of a firearm, who's attacked in any place where they have a right to be, has no duty to retreat, has the right to stand his ground and use force, including deadly force, if the actor has a right to be in the place where he was attacked. Fair enough. The actor believes it's immediately necessary to protect himself against death. So that's the elements of imminence and proportionality. And here's the wrinkle. This is a condition of stand your ground in Pennsylvania, the only state that does this. And the person against whom the defensive force is used displays or otherwise uses a firearm or replica firearm or any other weapon readily or apparently capable of lethal use. So unless that other person displays that weapon, you do have a legal duty of retreat under Pennsylvania law. You don't qualify for Pennsylvania stand your ground. Now, if they display a weapon, you do qualify for stand your ground. Did these survey authors gather this critical fact from their respondents? Would they even know to gather this critical fact? There's no evidence that they did. It's not mentioned. We're not told what rubric these judges applied. So we have to presume that each of these judges from these different jurisdictions applied the law as they understood it. That California would not require a legal duty to retreat, only 4 requirements for lawful self-defense. That Massachusetts judge would require avoidance. 5 elements are the test for lawful self-defense in Massachusetts. And the Pennsylvania judge would need to know whether or not the other person displayed a weapon to evaluate lawfulness. A fact which this study gives no indication was collected, probably because they didn't know.